Good morning. Please be seated. This is the time set for argument in HTA SCW Web Medical A LLC et al. Versus Roskamp Management Company, our civil number 16-0632. Each side will have 20 minutes within which to present their arguments this morning. The appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of your own time in that regard. We have read the briefs, been through the record, and we conferenced the case this morning, so we're fairly familiar with the underlying facts and issues that have been raised by the parties. So please keep that in mind as you make your arguments here this morning. We are recording the proceedings both by audio and video. The video will be available on YouTube in a matter of days. As you approach the podium, we'd appreciate it if you would identify yourself and your clients for us. And with that, appellant, you may proceed.
Thank you. May it please the court, my name is Doug Ress. With me is Michael Farrell. We represent the appellant Roskamp Management Company, occasionally referred to as RMC. I intend to reserve at least 2 minutes, but I understand the burden is on me. As we view the overriding issue in this case, the overriding issue is whether the court should look to extrinsic evidence and take into account all that's in the record in resolving the other two issues. The two issues being, one, whether the 2009 or the 2010 guarantee are operative, and the second being involving the language of the guarantee. I do not intend to address the attorney's fee issue unless the court has particular questions. Our view is the case should be reversed and the lower court award of attorney's fees vacated. But if that issue comes up, I'm prepared to address it. Throughout the argument and everything that overrides the briefing requires an analysis of the record evidence. And it requires an analysis with certain filters because, after all, this is summary judgment. So I won't bore the court with the standards. The court knows the standards. But one set of filters, or rose-colored glasses perhaps, is the standard on summary judgment in terms of giving credence to the material evidence put forth by HTA, not by HTA, but by RMC. And a second involves the filter with respect to how we look at guarantees, because guarantees are strictly construed such that in an issue we try to limit the guarantee as opposed to expand the guarantee. But
what's your
that,
best argument for the proposition that the 2010 guarantee is not effective? Is your best argument that it wasn't accepted?
It was never delivered for acceptance. And yes, it was never accepted. And
but the whole when the master lease was modified right after closing, so that the lessor changed from the Sun City entity to all 17 entities, the corresponding change in the guarantee had to be made. Otherwise, what's the point of the guarantee, right?
But the record evidence is that we notified the other side of the issue. We worked with the other side and tried to work with the other side to finalize the documents, and nonetheless, we put an extra $500,000 up at the insistence for a few weeks, and the other side refused to close on the documents. You know, Your Honor raises the issue of, it would be unfair perhaps if we apply the 09 guarantee. I don't ask this court to conclude that the 09 guarantee is the applicable one. I ask this court to conclude that that's something for the fact finder, to take into account all the facts that include the efforts by Ms. Galata to continually say, hey, let's get to the finish line. Hey, let's try to close. Hey, here's the document that is the signed guarantee that's in a packet of 4, 5, 6, 10 other documents. Let's get them all countersigned and give me my $500,000 back. And that was completely ignored. And the point I made earlier about let's look to the extrinsic evidence in terms of the overriding circumstances, that also applies to the issue Your Honor raises about, in essence, the fairness of why should 09 control. Had there been a reformation action, it still would be factually intensive. The issue would be, was there a mutual mistake? Well, certainly not. Ms. Galata told the other side, kept telling the other side. Is there a unilateral mistake governed by that is driven by fraud? Well, not in light of the communications.
I guess what I'm having a hard time getting my head around, though, is she said, in her email, said, yes, this is the form.
The form.
This is the correct form. The 2010 has been correctly amended to make the corresponding change that was made at the last minute, actually after the last minute of the master lease. And my client has signed it. Here it is. There's no signature line to be countersigned by any HTA entity. She didn't say it doesn't go into effect. We're not going to guarantee all bets are off unless we get the $500,000 back. And in reality, the $500,000 sat in escrow and ultimately was credited against the judgment. So,
well, the $500,000 was not credited against the $7 million cap, but I'll get to that. But what she said was, please have HTA countersign and instruct First American to release the $500,000. Her intention was, this is not operative yet. Her testimony was, this is not operative yet.
But in the KRW entity's view, the master lease was operative.
Yes.
Right.
Yes.
Well, so why is Roskamp able to pull out this one component document of a scheme that must have included more than a dozen and say, this one isn't operative. Everything else, yeah, we're good with everything else, but not this one.
The flip side is, why is HTA allowed to pull one out of a pile and say, this one's operative, but we're not signing the rest? That doesn't apply.
But the others were operative, whether or not they were signed or not. That's not an issue.
No, they were not. Not necessarily. Not necessarily, Your Honor. That's not correct. And I believe the lease was delivered earlier, and the lease was corrected early on.
Right, right. And
right.
Yeah.
Your Honor, if we were to be able to transport us back to 2011, 12, 13, 14, the first quarter of 15, and we said to HTA, what's the operative guarantee? The answer would be the 09 guarantee. The answer would be, this is the guarantee that's given to Sun City, not to HTA, the 17 entities. They brought suit on it. They filed summary judgment on it. They, right before summary judgment, assigned a document that now you're being asked to conclude was not even operative. It's for the fact finder to go through all of this and look at all those facts and determine, is it 09 or 2010? It may turn out to be 2010, but it was not one for purpose of summary judgment in light of all those facts. Indeed, we're the people that brought to the attention of the other side, hey, by the way, there is this document. We could have, I suppose, simply opposed and said the 09 doesn't work because it's to the benefit of Sun City. And then perhaps the response would have been, let's amend, let's do a reformation action to get to the heart. And in that action, it would have been, there's a unilateral mistake, and it should be reformed for inequitable conduct. And the question is, factually, was RMC behaving in an inequitable fashion? Fact finder might say yes, but in light of all the evidence in terms of Ms. Galata trying to bring everything across the finish line, I think the answer is no for purposes of summary judgment. So while the court might struggle that, gee, it sure makes sense that maybe the 2010 should apply, that's something for the fact finder, not for us today on summary judgment.
There was an arbitration proceeding at some point here between HTA and,
yes,
and KRW. Is there any claim preclusion applicable here?
No.
Why not?
Because the issues in the arbitration were not the issues on the guarantee and the language of the guarantee.
Well, there's one that was. It was the arbitrator's finding that third-party rents were intended to go as security to the make-whole note, not to satisfy the master lease obligations.
I respectfully disagree, Your Honor, and here's why.
Oh. You made the finding.
Oh, no. That finding is absolutely found. There's no challenge to the arbitrator's findings. That binds the lessee. We're done. That's beyond dispute. But in that finding, which included an analysis such as in the lease agreement itself, you waive defenses, et cetera, when we look to the guarantee, it's the guarantee that determines, okay, the lessee owes the moon and the stars. Now how much does the guarantor owe? And the guarantor owes amounts that are, shall be reduced by amounts paid to lessor outside of the escrow account.
You're talking about paragraph 3?
Well, it's in paragraph 3 as well as in, yes. There's similar language in paragraph 9, but it's really paragraph 3, paragraph 5 has that phrase that the obligations are reduced by amounts paid to lessor outside of the escrow account. That phrase was not discussed. It wasn't analyzed. It wasn't addressed. The guarantee, let alone the 2010 guarantee, which was in everyone's possession, wasn't on the table for the arbitration.
What's the best argument under paragraph 3 for why the judgment should be reduced? In other words, what I'm getting at is what is your best argument for the amounts contained in the escrow account or paid to lessor outside of the escrow? Are we talking about the third-party rents?
On the paid to lessor outside of the escrow account, yes.
Okay. Anything else any argument that you're making under paragraph 3?
Well, yes, but they give us credit. That's not in dispute.
Okay.
So, for example,
so it's the third-party rents. That's what we're here
that
for.
really is. There may have been interest and other things they received outside of the escrow account or other payments, but it's really the third-party rents of about $1.5 million at least.
Okay.
Yes.
Well, under your position then, that the third-party rents get credited in Roskamp's favor under the guarantee, the KRW Roskamp entities then would get credit for that twice, even though HTA received it just once.
Not the KRW entities. There's a difference here, Your Honor. First, there's the issue of the lessee, which is a shell company, and everyone knew it was going to be shell because everyone understood once the money comes in, it's going to be distributed. Then the issue is, okay, under the guarantee, how much of a guarantee am I taking on? And that requires an understanding of the circumstances surrounding the deal. We wanted a deal that said, we'll sell you give me $100 million. Instead, they said, no, we want it to look like there are rent rolls, so let's make it 107, and we'll figure out how you give us back 7. Still be $100 million to you. That was a creation of HTA. And so then the question is, under the guarantee with that language, paid to lessor outside of the escrow account, was that in the arbitration? Was that analyzed in the arbitration? Was that discussed in any way in the arbitration? The answer is no. And while we don't have the full arbitration transcript, we certainly have the interim and final award, and it's not there. It wasn't part of it. So while the lessee may owe $40 million, then we come to the guarantee and say, okay, how much did you take on to really pay us back? But, Your Honor, we're on paragraph 3. It's important to start with the language that the obligations of guarantor, that phrase, shall be reduced by amounts contained in the escrow agreement. There was...
And that happened. And that happened after the arbitration, the escrow agreement was exhausted, or the escrow was exhausted.
Yes, but we didn't get full credit because the obligations of guarantor, on day one, we had $3 million in the escrow account. We gave a $2 million note for a total of $5 million, which, and what was being crafted here was a response to a request that we sign a guarantee, we, RMC, sign a guarantee that be absolute, unconditional, without caps. And the answer was, no, that is rejected. We're not doing that. We're putting a cap of $7 million on. Okay.
So but I'm trying to understand what is Roskamp's argument, what does Roskamp say in paragraph 3 that it didn't get credited for? The third-party rents, that's what I hear.
That's one.
What else?
And the $5 million that was put up. From the get-go, there was a $7 million exposure, as expressed in paragraph 9, And the exposure, the obligations had to be reduced by $5 million so that on day one, there was no more than a $2 million exposure. That is what was trying to be accomplished by the language.
Where do I see the $5 million come in here?
Well, we know as a matter of fact, of record, that there was $3 million cash in the escrow. It actually was 2.5 by agreement, and then at the last minute, here's 500. It would make no sense to put 500,000 in the escrow account
But you got credit for that.
not for the $7 million. No.
Well, now that's an argument under paragraph 9.
Correct. But, Your
Okay,
Honor,
let's go to paragraph 9.
okay.
It seems like Roskamp again is asking to be credited twice for payments that HTA got once.
Paragraph 9, just as paragraph 3, does not stand alone. And while Your Honor may be struggling, that suggests that Ms. Galata, and maybe not struggling perhaps, but we believe Ms. Galata needs to be heard, finally. She had a voice. She did this. She crafted it to reject the absolute unconditional document without caps. And she tried to structure it so that in paragraph 3, she knew there was at least $3 million in the, or 2.5, then 3 in the escrow account. There was a concern that someone might say, gee, that note, it's not really in the escrow account, so let's also make sure we say something about the note. But all told, there was really $5 million in the escrow account. Milligan, the HTA corporate rep, actually testified to that. And I can provide the site, but that's in IR 54 on page 123 and 124 of his deposition. That was the intention, that there was $5 million toward the 7. Now, Milligan said something else quite important, which is this notwithstanding language applies to the whole document. There's an argument that has been expressed that I'm trying to render, or our Roskamp management is trying to render the other provisions meaningless. Attorney's fees in paragraph 2, attorney's fees in paragraph 22 or 23, whatever it is. And that's not correct, because had the arbitrator ruled, I award $100,000, $50,000 of attorney's fees, $10,000 of interest, it would be within the cap. There would be an attorney's fee provision. The only issue is when the cap kicks in, not whether the attorney's fee provision is for all intents and purposes at all times meaningless. And when we look at paragraph 9, the first clause says the obligations of guarantor are limited to $7 million, and then minus.
Okay, so minus the amount of any payments made not from amounts deposited in the escrow. And the second part is minus the amount of any permitted investments. Now, I don't understand your brief to make any argument concerning the amount of permitted investments.
Well, that's because that's part of the $5 million.
That's the $2 million note.
Correct.
Okay.
Yes.
Okay, so that's the $2 million. What is, under your view, the amount of any payments made to lessor not deposited in the escrow? Is that the third party
rents?
Okay, so you're making the third party rents in both sections. It
Yes.
reduces the obligations,
Yes.
and it reduces the cap.
But what's important, Your Honor, is that as a matter of simple math, paragraph 9, when it says the obligation is limited to $7 million, it could have been minus a zillion things. It can never be more than $7 million, because 7 minus whatever number never goes above 7. And whether Ms. Galata did not express it perfectly, nonetheless, the fact finder is the one to hear from her under the crucible of trial and determine what the parties were trying to accomplish, which takes into account all that extrinsic evidence I referred to. I have 2 minutes left, so with that, thank you, Your Honors.
All right, counsel, thank you.
Good morning, Your Honors. Randall Edwards on behalf of plaintiff appellees, the 17 HTA entities. I'd like to begin to address each of the three, what I understand to be the three central matters of dispute. One is whether the cap in paragraph 9 in any way limits the judgment that Judge Bergen entered based on Judge Gama's summary judgment order. Second, whether paragraphs 3 and 5 reduce the amount that is owed. And finally, I'd like to address the question of the operative guarantee in 2010. So to begin, the amount that was owed under the master lease by KRW, which Roskamp has admitted it was the managing member of, and at various times in the briefs is referred to it as indirect subsidiaries. That judgment amount was determined in a multi-week arbitration. It was entered as a judgment by Judge Brain. It's not appealable. So that's a fixed amount. The guarantee, the undisputed evidence is, and when I say undisputed evidence, I will refer to times in which Roskamp management in the separate statement of undisputed facts stated undisputed in response to statements that we made. The undisputed fact is that KRW and Roskamp intended to induce HTA to pay KRW $107 million for this series of medical office buildings. The guarantee was part of the necessary inducement, and President of Roskamp Management Company, Dan Sevick, admitted that he understood that. It's also in recital D of the guarantee itself. The guarantee in paragraphs 1 and states that it's an absolute, irrevocable, unconditional guarantee of amounts that were owed under the master lease by KRW. Paragraph 2 then provides for things such as interest, attorney's fees, and other related expenses that might arise in the event, as what happened here, that KRW didn't honor the master lease. Paragraphs 3 makes it was in all of the drafts. There was a language modification at the end, but there was in all of the drafts. Paragraph 3 essentially said HTA can't double dip. It can't get credit under the guarantee and sue Roskamp Management Company under the guarantee for amounts that it already has collected for the master lease obligation. And then at the end, just before the closing, Roskamp Management Company added paragraph 9. Paragraph 9 is the cap. And the cap simply doesn't apply. And I'd just like to walk the court through that very simply. So the judgment that we obtained in the court below was for $4.1 million, which was $3.6 million of still unpaid amounts of the KRW judgment for their breach of the master lease, and then approximately $500,000 in attorney's fees and costs associated with that. So $4.1 million is the amount of the judgment that we're arguing about today. The cap is $7 million minus two things. The first thing, I'll take them in reverse order, it's just a little simpler. The second thing that the cap subtracts out is the amount of permitted investments. It is undisputed that the amount of permitted investments is $2,073,000. The separate statement of facts, paragraph 60, which in the index of record, the Roskamp's response is 52, index of record 52, but it's the separate statement of fact. 60 admits, not disputed for this motion, that that's what the permitted investment is. Permitted investment was a defined term in the cash collateral agreement. It included a note. It did not include cash. Period. Full stop. The other exclusion under the cap was the amounts, and I'd like to just read the language so I quote it accurately, the amount of any payments made to lessor, that's my client's HTA, under the capital L lease, that's the master lease, that have not been made from amounts deposited in the escrow account. So separate statement of facts 58, Roskamp agreed that it and KRW made no payments outside the escrow account under the guarantee. In paragraph 59, they admit that arbitrator Aiken determined that the third-party leases were not payments under the master lease. And that's consistent with, it's on page 2 and on page 8 of the interim award that arbitrator Aiken entered. And that interim award became a final award. The only thing that changed was he added attorney's fees after we litigated that issue. And that became the final non-appealable judgment from Judge Brain. So the cap, which begins notwithstanding anything else in the agreement, it'll be $7 million minus the amounts paid outside the escrow account. That's zero as a matter of undisputed fact, because Roskamp Management Company admitted those facts, and they had to. They had to, because neither Roskamp nor KRW paid monies outside the escrow on the guarantee. KRW had made some initial lease payments before there was the initial breach, but Roskamp paid nothing on the guarantee, and the third-party leases were not payments under the lease, as so held by arbitrator Aiken. They were payments made by third parties under third-party leases. So that's zero. So it's $7 million minus zero, minus $2,073,000. It's just over $4.9 million. That's the cap. Notwithstanding anything else, there'll be a $4.9 million cap. We're seeking to gain affirmance of a judgment of $4.1 million. The cap simply doesn't apply under the plain language of the cap. So I'd like to turn to paragraphs 3 and 5, unless Your Honor has a question.
It's nice for HTA that paragraph 9 ties the cap to payments made under the lease.
Yes.
What's your similar argument as to why the third-party rents are not captured by paragraphs 3 or 5?
Yeah, sure. So let me address that, Your Honor. So in paragraphs 3 and 5 are designed to prevent double dipping, right? So the first question is, it's the guarantee, again, let me apologize, let me turn to the exact language so I quote it accurately. So it begins, the obligations of guarantor hereunder. And then it has some language that's not relevant, but ends in the important language, shall be reduced by any amounts in the escrow account or paid to lessor outside the escrow account. So to understand what this is, first looking at what are the obligations of the guarantor hereunder. Hereunder refers, of course, to the master lease guarantee, the subject of which it's guaranteeing the obligation of the master lease, as well as interest and attorney's fees and late fees in the event of a breach. So that's the subject matter of what 3 is talking about. We will reduce the amount related to the master lease and the master lease guarantee in the event that certain things happen. One is payments, any amounts contained in the escrow account. That actually shouldn't be disputed. It's $5.2 million. It's not 7 minus 5.2 million, because the obligations of guarantor hereunder, when one looks at what that means under paragraphs 1 and 2, it's the $7 million master lease, it's attorney's fees, it's interest, and the like. The cap comes later. But there's been full credit for the payments that KRW made under the escrow account, and then the language paid to lessor outside the escrow account. And so the argument, as I understand it from Roskamp, is that amounts paid to the lessor, that's HTA, outside of the escrow account can include anything, whether or not under the master lease, or related in any way to the master lease, or related in any way to
Or paid by anyone.
Paid by anyone for any reason. So under to the only reasonable construction of the sentence when you say paid to lessor outside the escrow account, referring back in the same sentence to the obligations of guarantor hereunder, is to look back to what is the source of the obligations of the guarantor. It's the master lease itself. To say that payments made to HTA, not on the master lease, but by third parties pursuant to some third-party contract, not under the master lease, would make no sense. It wouldn't be a reasonable construction. If there were a vending machine on the property, or if there were a vending machine that one of the HTA entities owned on a different property, or any other possible source of income, one could say, well, that's a payment to HTA outside the escrow account. But it's untethered completely to what paragraph 3 and the entire master lease guarantee is related to, which is guaranteeing the obligation of KRW, inducing HTA to pay over $100 million based on this master lease. And the purpose of the guarantee is something that we asked the president of Roskamp Management Company, presented to Judge Gama in the summary judgment papers. They understood the purpose was to de-risk the transaction from HTA's perspective. And that is, so in the index of record, the evidence that we cited was, it's number 48, and it's Exhibit 12 is Mr. Sevic's deposition testimony within that. And he admitted he understood the purpose was to de-risk the transaction from HTA's side. So it was, the guarantee is tied, of course, to the master lease. And so when construing paragraph 3 and similar language in paragraph 5, would payments unrelated to the master lease that Arbitrator Aiken actually found were on the make-whole note, as Your Honor observed, different payments, would that reduce the guarantee obligation? That's not a reasonable construction, I would submit, because the entire purpose of the master lease guarantee is to make sure that if the indirect subsidiary, KRW, fails to make payments, Roskamp Management Company will stand behind it. And that's no idle consideration. The separate statement of facts, paragraph 13, I believe it is, Your Honor, was I apologize, let me confirm. It's paragraphs 4 and 5 of the separate statement of facts. It's undisputed. KRW wasn't planning to retain the money in order to be able to pay the master lease. It was to be distributed upstream to a parent and then ultimately to the principal, so that the master lease guarantee was the only means that HTA ever was to have to receive the balance of the lease payments.
I think the argument, though, is that the master lease allowed the HTA entities to lease out some of the master lease property to someone who would actually pay. I think that's the argument. So the master lease did envision that there could be a stream of rents coming from someone else.
Well, certainly the overall transaction contemplated is actually the agreement regarding make-whole address that issue. The master lease did not prohibit it, and I would. So I'd say that Arbitrator Aiken in page 2 of the interim award walked through, I thought, in a very helpful several series of bullets, that the $7 million obligation from KRW that was guaranteed by Roskamp was fixed at $7 million. HTA, because it contributed $2.5 million to a senior lien holder on a KRW debt, also had the opportunity to try to recoup that through the third-party leases, but that those payments were not under the lease. And so when looking back at the whether there should be a reduction in paragraph 3 to the master lease guarantee obligations, should that count what third-party rents, there's simply no nexus in paragraph 3. It's referring back to the obligations of the guarantor hereunder.
Yeah, the Roskamp wasn't guaranteeing the make-whole note.
That's right.
KRW had secured by the rents, the third-party rents.
Yeah, so Roskamp was not guaranteeing the third-party note. So if it were the case, as Roskamp now argues, that the guarantee obligation should be reduced by these third-party rents, you would have a circumstance where the master lease obligation isn't reduced by those third-party rents. That's unappealable, so held Arbitrator Aiken. But the guarantee somehow is, and there's never been any testimony to explain why a reasonable fact finder, it would be the judge in this case because there's a jury trial waiver in the guarantee, but why the trial judge would ever conclude that there was an intention to create that discrepancy so that the master lease guarantee guaranteed something, the scope of the guarantee was somehow a smaller scope than what the master lease itself obligation was. And in light of paragraph 1, I would submit it's simply not reasonable. Now, paragraph 9, the cap is different, right? It begins with, notwithstanding anything else, we're going to cap it at a certain amount, but I've already walked through the math on why the cap simply doesn't apply. Let me just address briefly the issue of whether the 2010 master lease guarantee is the operative guarantee. So I think there are a few undisputed facts that are critical here. One undisputed fact is that Robert Roskamp signed the master lease guarantee on behalf of Roskamp Management Company, and it was sent. There were dozens and dozens of deal documents. He signed the April 2010 one, and it was sent to HTA. There was no expectation of a countersignature. There was no space for a countersignature. And the testimony was it's a unilateral contract. There wouldn't be a countersignature on that document. There was a discussion immediately before close. There was a great rush towards close on this very large transaction, dozens of deal documents towards December 31st, 2009. One of the last changes was a note that we're going to need to change which HTA entity is on the master lease, and there'll be some other cleanup documents. Separate statement of undisputed fact 9 is that at the time of closing, both parties understood that certain deal documents would need to be revised post-closing. Roskamp Management Company's response in their opposition to summary judgment was that's undisputed. It was known. In January of 2010, there was an exchange on the master lease guarantees, substituting in the HTA entities that had previously been substituted in on the master lease. There was an exchange of emails in March, and these are exhibits 14, 15, and 16 in the summary judgment papers. There's an exchange of emails where the transaction counsel for HTA said, I believe these the final form of the document, and Ms. Galata on behalf of Roskamp Management says, yes, confirmed. She asked, what's next? And then Mr. Roskamp signs it, and it's sent. The argument that I understood from a few moments ago was that there was not some acceptance of delivery. Paragraph 17 expressly waives any notice of acceptance, period. And then the other point I'd like to address is just the intent of whether it would make any sense to have the HTA entity on the guarantee different than the HTA entities on the master lease. So this is in Exhibit 13 of our summary judgment papers, which is part of Index of Record 48. I asked Ms. Galata, but was there ever a time when Roskamp Management intended the HTA entities to be different on the master lease than the HTA entities listed on the master lease guarantee? Her answer, as the lead transaction lawyer and as the 30B6 witness, was not to my knowledge. No evidence at all, let alone evidence that a reasonable fact finder could find to create any ambiguity on the point. No evidence at all that there was ever an intent to have the master lease guarantee and the master lease have separate HTA entities. The history shows that the signed document delivered by Ms. Galata that Mr. Roskamp signed establishes that. It is the only way to give effect to what Roskamp has admitted was critical to both parties to induce HTA to enter into the transaction.
It's a little awkward, though, that the 2010 guarantee didn't show up in the litigation until after a while. Did Roskamp argue before the 2010 guarantee showed up that it owed nothing under the 2009 guarantee?
So for the first 2 years of the litigation was filed, and then it was simultaneous with the arbitration. Essentially, litigation was stayed for 2 years, and it revived. There was, I believe, Roskamp argued in a disclosure statement that came out about a month. It may have been 2 months, but just when the summary judgment, I'm sorry, when the state court litigation began, it did make a point that that the guarantee guaranteed nothing, and the reason that it didn't show up is quite honestly there was litigation counsel for HTA was just not aware of the fact. We thought we had the signed document, and the issue of the guarantee was not the focus until after we had gone through the arbitration.
After the arbitration.
Very good. Thank you, counsel.
Thank you.
Thank you.
You may.
As I understand it, this court's being asked to basically take white out to paragraph 3. Paragraph 9 wasn't added, and it isn't something that we look at in a vacuum. We have to look at 3, 5, and 9 in the whole document together in terms of what was trying to be accomplished. And while there may be a discrepancy in terms of what the tenant, the lessee, might owe, that discrepancy is a function of the extrinsic evidence as to what the $100 million expectation was of RMC. Yes, it was known that there would have to be revisions to the documents. And yes, we admitted that we did not ourselves pay outside the escrow agreement, but there were payments outside the escrow agreement. In paragraph 3, it starts out with the phrase, the obligations of guarantor, and then goes on to, shall be reduced by the amounts in the escrow. Then you get to paragraph 9 that says, it can't ever go above 7. That's it. You may conclude that the rest of the language in paragraph 9 is superfluous, but I think what she was trying to accomplish is that if someone says the escrow agreement's only $3 million and the note's outside that, I better also in paragraph 9 say, by the way, you also take off the $2 million. What's really going on here is Stacy Galata's voice was shut down throughout. On December 31st, the $500,000 deal was struck outside her presence. When she's writing saying, let's get this to the finish line, they write directly to the client. She then has a declaration that lays out what she was trying to accomplish, and it's been ignored, never put to the crucible. That's what we ask of this court. Thank you, Your Honors.
Thank you, counsel. We appreciate the arguments here this morning and the briefing that was submitted on this matter. We're going to take the appeal under advisement. We'll issue a written decision in due course. And with that, we are adjourned. Thank you.